Welcome back to On the Record. I'm Cody Thomas, and we've officially wrapped week 7 of the Karen Reed murder retrial. Now, this week, the tension in the courtroom hit new highs. We saw hostile witnesses, scientific testimony get ripped apart on cross, and a second call for a mistrial, all as the defense works to poke holes in the Commonwealth's case. From a former cop flipping on the stand, to dramatic cross about dog bites, to a snowplow driver whose story changed under oath. This week had it all. Now, before we break it down day by day, let's get you caught up on the case.
The death of Boston police officer John O'Keefe on a snowy January night in Canton ignited a firestorm of controversy, much of it centered around a cracked tail light. Prosecutors allege that Karen Reed, O'Keefe's girlfriend, struck him with her SUV and left him to die in the front yard of 34 Fairview Road. They point to the broken tail light as crucial evidence, claiming it matches injuries on O'Keefe's body and glass fragments found at the scene. But Karen Reed's defense argues the taillight was broken after the fact by investigators themselves, and that she is being framed to protect others. Supporters of Reed have rallied behind her, insisting the taillight is part of the cover-up. With dueling experts, impassioned crowds, and mounting suspicion on both sides, the broken taillight has become more than just a piece of shattered plastic. It's the symbol of a case cracking open at the seams.
Day 25 kicked off with some serious tension in the courtroom. The defense called former Canton police officer Kelly Deaver to the stand, and what started as routine testimony turned testy real quick. Deaver was treated as a hostile witness after dropping a bombshell. She claimed one of Karen Reed's attorneys told her to lie on the stand or face perjury charges. She had originally told investigators that she saw Karen Reed's SUV parked alone with then Canton Police Chief Kenneth Berkowitz and ATF agent Brian Higgins for what she said was a, quote, wildly long time. But in court, she retracted, saying she got the timeline wrong. Then came Dr. Marie Russell, a forensic pathologist and dog bite expert. Her testimony leaned heavily into the defense's theory that John O'Keefe may have been attacked by a dog and not hit by Reed's SUV. She pointed out tearing patterns and grouped injuries on O'Keefe's arm that, in her expert opinion, looked consistent with a canine bite. Now, she even suggested a hole in his sweater might have come from a dog's tooth. But the prosecution was not buying it. They pushed back hard, referencing the official medical examiner's report, which found no puncture wounds. To wrap up the day, the defense went after the integrity of the investigation itself. They called Jonathan Diamandis, a longtime friend of the lead investigator, Michael Proctor, to talk about some pretty inflammatory texts Proctor had sent. Diamandis didn't testify to any sort of framing or planted evidence, but jurors got to hear Proctor's actual words, calling Karen Reed a, quote, whack job, mocking her medical issues, and saying from the jump that she was guilty.
Sir, do you know former trooper Michael Proctor?
I do.
How often have you texted him over the years?
Frequently.
And when you text him, is that direct one-to-one or part of a group chat or both?
Both.
And I want to direct your attention to one particular group chat that had 9 people on it. With regard to the 9 people on that group chat, you're one of them?
Correct.
And whether or not Michael Proctor is on that group chat with the rest of your high school friends as well?
He is, yes.
Sir, do you know if Mr. Proctor was fired from the Massachusetts State Police?
I do.
Did he tell you why?
It was in connection to this case. I believe it was based on his text messages that were sent to us.
I'd like you to look at the 3rd text message that begins with Chip. Without saying who it is, do you recognize that as one of the people in the group?
I do.
And what did the person write?
Chip, name of that BPD cop.
Turn the page. Bottom right number is ending in 28. Instead of a name, there's a local user with an ID. Is that Mr. Proctor's?
Yes, it is.
And does he respond to Chip, name of that BPD cop?
He does.
What does he say?
John O'Keefe.
Let's turn the page, ending in 39. These begin in January 29, 2022, 11:06 p.m., 55 seconds. Is that accurate?
Yes, it is.
Mr. Proctor responds, 0 chance she skated. She's.
Yes,
Is that what he said?
it is.
In your conversations with Mr. Proctor, has he ever suggested that he planted evidence in this case or any other case?
No.
In your conversations with Mr. Proctor, has he ever suggested framing a defendant, including this defendant?
Absolutely not.
You were contacted by the defense?
Yes, prior to the first trial.
You mentioned that somebody had suggested you be charged with perjury?
Yes.
Who did that?
One of the male members of the defense team. They were looking for me to say that I saw Higgins and Berkowitz in the garage with the car.
Did you share with them that that wasn't an accurate memory?
Yes.
How did they respond?
They became very aggressive, raised their voices, and the one word that I can very definitely remember is they said that they would charge me with perjury. That was essentially the thing I remember most, because I understood that was what they wanted me to provide for the trial. I was never called for the first trial, therefore I'm not exactly sure what else there is for me to say when the one thing that they wanted on the stand, it is factually not correct and cannot be provided.
When they threatened you to charge you with perjury, tell us what your state of mind was.
Disappointment that legal counsel would go that route.
Based on your review of all the materials that you had described and your experience that you had described, without stating it, were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
They were inflicted as the result of a dog attack.
And how did you form that opinion? Just describe your thought process to the jury.
So there are multiple groupings of wounds right here. Here's one on the what I'll consider the upper arm, which is above the elbow. Here's another grouping. Here's an interesting, complex grouping at the elbow. These are all at the posterior surface of the arm. And there's another grouping down here on the forearm. These multiple groupings are patterns. And they are, in my opinion, were inflicted by the teeth and claws of a dog.
You weren't called by anybody on the defense and retained as an expert in the traditional sense, were you?
That's correct.
You wanted to get involved in this very high-profile case, didn't you?
I thought I could help clarify the issues as to whether or not this could be a dog bite, and maybe they could move on to something else if it wasn't.
So, Dr. Russell, from your perspective, as far as you know, you were the only person in the entire United States of America who was qualified to look at a photograph and make a determination whether the wound was derived from a dog bite.
No. I am one of I'm the only physician that I know of that can do that.
The defense once again called for a mistrial right out of the gate on day 26, this time over the mention of dog DNA. It happened during the cross-examination of the dog bite expert. The prosecution brought up the fact that no canine DNA was found on John O'Keefe's clothing. Now, the defense said that line of questioning was unfair and, quote, intentional misconduct. But the judge disagreed and let the testimony continue. Dr. Russell stuck to her opinion that O'Keefe's arm injuries were consistent with dog bites, specifically canine teeth. She told the jury her opinion had, quote, become more certain since the first trial. But under pressure, she admitted there are no official medical standards for for identifying dog bite wounds the way she did. Then came testimony from Sergeant Nicholas Barrows, who helped collect Karen Reed's SUV from her parents' home back in 2022. He told the jury the taillight was cracked and had a chunk missing, about the size of a dollar coin. But when shown a photo of the SUV after it was moved to the police station, he said it didn't match what he saw before transport. Now on cross, Barrows said he never saw any officers tamper with the vehicle, but he admitted his report barely mentioned the damage. Just one sentence. And when asked, he admitted he's been following coverage of the trial online. All in all, it was another full day of contradictions, questions about evidence handling, and yet another failed mistrial attempt.
Can you point to one place, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth, correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
When you were trying to rule out a collision between Mr. O'Keefe and Miss Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and timing?
A broken taillight in and of itself could not cause those injuries.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Attorney Brennan asked you several questions with regard to whether those 1/16 of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern?
I don't believe so.
How do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions, so these pieces would need to be lined up in a certain configuration to cause those abrasions.
Please state your evaluation and conclusion and the basis for it as to whether those shards of shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
Finally, on day 27, the jury heard from someone with a different view of that snowy night. Literally. Snowplow driver Brian Lucky Loughran told the court he passed by 34 Fairview multiple times between 2:40 and 6:15 a.m. the morning John O'Keefe was found. And each time, he said he didn't see a body in the yard. He also mentioned something interesting, a Ford Edge parked outside the house. He says it wasn't there during his first pass, but it was there later. But the thing is, right after the incident, he told a private investigator it was actually parked on Cedar Crest Road, not Fairview Road. Prosecutor Hank Brennan drilled into that. He even asked Loughran if he was pressured by Aiden Kearney, aka Turtle Boy, the controversial blogger who's been all over this case online. Loughran said no, that he just wanted to be left alone and that internet rumors had no impact on his testimony. Now, outside of court, Kearney denied threatening Loughran and told reporters, quote, absolutely not. Also on the stand that day was Karina Kolakithis. She knew John and Karen through a kids' sports program. She told the jury about seeing a sweet moment between them the night before John died. She said John hugged Karen and kissed her right on the forehead, calling it, quote, the sweetest thing. But things got weird when she talked about Jennifer McCabe. As the group was leaving the bar, the witness said McCabe wrapped her arm around Karen and told her, quote, you're coming with me, you're coming with me. She thought it was strange, and when asked who got into the driver's seat that night, Kolakithis said it was Karen.
Directing your attention to January 28th and 29th of 2022, were you on duty as a snowplow driver that night and early morning?
Yes, we were to report at 2:30 in the morning and prepare our trucks for plowing.
How much of the front lawn of 34 Fairview could you see?
I could see all the way to the front door.
What was on the ground on the Alberts lawn at that point in the area of the flagpole?
Nothing.
Did you see a 6'1", 216-pound man lying on that lawn?
No.
Is there a point in time when you come back to the area of Fairview Road?
Yes.
That second time now that you're coming back, about how long is it after the first time?
About 45 minutes.
So now it's about what time that you're coming for the second time to this area?
3:30.
Describe for the jury what you see in the road at that point.
As I make my right onto Fairview, I notice that there's a vehicle on the right-hand side, roughly in the area of the flagpole, in front of 34 Fairview.
And did you make note of what type of vehicle that was?
Yes.
What type of vehicle was that?
A Ford Edge.
What, if anything, did you see on the ground in the area of the flagpole?
I saw nothing.
During the pendency from that night until today, it's fair to say there are many times where you have been intimidated, isn't it?
No.
You've been threatened.
Nope.
You were aware, sir, that you were being threatened by an online blogger to expose you?
I was not.
You knew there was pressure for you to testify a certain way in this case, didn't you?
I did not know I was being required to testify a certain way. I was also at the time dealing with the loss of my wife. I was not paying any attention to any social media.
When you plowed that night, did you have any reason to look for somebody who was lying on the side of a yard?
No,
Did you have any expectation somebody would be lying helpless on the side of a yard that night?
no,
If you had seen somebody, certainly you would have helped.
correct.
Directing your attention to January 28th of 2022, do you recall that being a Friday?
Correct.
What did you do that day?
So that day I worked.
Do you recall what your hours were?
Approximately, I would say 8 to 4:30 that day.
What were your plans that night?
So my plans were to stay home. I was tired. I worked all day, watched the game.
At some point, did those plans wind up changing?
So then I started getting text messages from my husband saying, you should come out. We're going to go to the waterfall. I reluctantly went. So my husband had eaten, and I said, you know what? I think I'm going to get going. And I was about to get going, and then John and Karen walked in.
How much interaction did you see that Karen had with John O'Keefe?
They had some interaction.
And did John come over to Karen at one point and do something?
He did.
What did he do?
So John went over to Karen, and he gave her a kiss on the forehead.
Okay, and that kiss on the forehead, why did that stand out to you?
Honestly, I'd never seen something like that before, a boyfriend do to a girlfriend in public. Never saw that. So it just stood out to me. I was like, wow, that's the sweetest thing I've ever seen.
After a break on Thursday due to extreme heat, things picked up again Friday with key witness Dr. Daniel Wolf taking the stand. Wolf's an accident reconstruction expert with ARCA, and he's no stranger to the case. He also testified during Karen Reed's first trial. Before the retrial, he took it a step further. Wolf ran additional tests using a Lexus SUV similar to Reed's, along with both a crash test dummy and a Rescue Randy mannequin to simulate potential impacts. Now, his goal was to see if the taillight damage on Reed's SUV could match what would happen if she struck John O'Keefe. Wolf told the jury that none of the impact tests he ran replicated the kind of damage seen on Reed's vehicle. And notably, none of the tests tore or snagged a hoodie in the same way O'Keefe's was found. But on cross, Special Prosecutor Hank Brennan came in hot, challenging Wolf's calculations and the choice of test materials. He pointed out that Wolf used a dummy arm that was lighter than O'Keefe's arm, which would cause less damage at the same speeds. Wolf admitted the difference. He also responded to a photo Brennan showed of a torn crash dummy sleeve, saying the sleeve was damaged, but from road rash, not impact. While Wolf stuck by his testing, the prosecution pressed hard on whether those tests really reflect what happened that snowy morning.
Were you able to review photographs of not only the Lexus involved, but John O'Keefe's body?
Yes.
Were you concluding, or did you opine, that the damage to the taillight came from a drinking glass?
No, I gave an opinion that the damage was generally consistent with that in the test, compared to the subject taillight.
But only in the circumstance where the glass is being hurled at 37 miles an hour, correct?
Sustained. Can I ask it differently?
Under what circumstance did you determine that it was consistent with a drinking glass?
If that drinking glass, again, the purpose of the test was to do a test to evaluate or simulating somebody throwing a drinking glass at the taillight. So that's what that test was to demonstrate.
Why was it important to do a drop test?
So we wanted to have an understanding based upon the fact that Mr. John O'Keefe had a skull fracture to the back of his head, whether or not an impact, a direct impact between the taillight and the back of his head could have caused that skull fracture.
What did your testing indicate?
When we did the test, the impact to the taillight was at 15 miles per hour, and we observed that the damage to that taillight was significantly more than the subject taillight at the 15-mile-an-hour speed. Furthermore, it did not generate, according to my colleague, Dr. Rentschler, enough forces to cause a skull fracture.
So ultimately, what was your conclusion related to the taillight potentially striking John O'Keefe in the head at above 15 miles an hour?
From a damage perspective, it was inconsistent.
With regard to this particular 10-mile-an-hour test, what did you note in terms of the damage to the taillight?
It was very minimal.
And what did you note in terms of any damage at all to the hoodie?
There was none.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes.
At some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year. Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
You know, Mr. O'Keefe's 6'1". You used a crash test dummy what is the height on it?
Well, the ATD, I believe, is 5'7".
You said 5'7". It's actually 5'9".
Sorry, 5'9", yes.
5'9". And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole body.
He wasn't 5'9".
Correct.
Now that wraps week 7 of the Karen Reed retrial, and if you thought the tension was high this week, just wait. The courtroom isn't cooling off anytime soon. We've got at least 2 more defense witnesses coming, a likely rebuttal case by the Commonwealth, and more questions swirling around what really happened to Boston police officer John O'Keefe. I'm Cody Thomas, and as always, thanks for listening. Stay safe, stay informed, and we'll see you next time we go back on the record.